Hi, everyone. Good afternoon, and welcome to today's training, an introduction to post-dispositional SYTF collaborative court. Before we get started, a quick reminder that this session is being recorded. I'll be emailing out the handouts and MCLE proof of attendance after the training, so keep an eye out for those in your inbox. As we go through the presentation, feel free to submit any questions in the chat, or actually it'll probably be the Q&A for you all. We'll do our best to respond directly there, and if time permits, we'll have a Q&A at the end to cover any remaining questions. Now, it's my pleasure to introduce our four accomplished presenters. First, we have Jane Brownstone, a deputy district attorney here in Los Angeles with over 8 years of experience. Jane is one of two line attorneys in the complex litigation unit, where she manages around 110 post-dispositional youth in probation secure youth treatment facilities. She also coordinates diversion programs for juvenile cases in partnership with the Department of Youth Development and prosecutes complex juvenile matters, including competency issues and transfer hearings. Previously, Jane prosecuted serious felonies and misdemeanors throughout the county, handling cases involving homicide, sex crimes, domestic violence, and gang activity. Next, we have Courtney Dyer, a deputy district attorney with over 8 years in Los Angeles County. Following her earlier role as a deputy district attorney in Contra Costa County. As the other of the two DDAs in the complex litigation unit, Courtney oversees 130 SYTF post-disposition cases across LA County. Previously, she served in the Victim Impact Unit, where she prosecuted cases involving domestic violence, adult and child abuse, and elder abuse. Joining us as well is Jamie Marcus, a dedicated public defender with 18 years of experience. Recently, she transitioned to the alternate public defender's office to work specifically with the SYTF collaborative court. Jamie brings extensive knowledge from her time in juvenile court, where she represented youth with special education needs and developmental disabilities. And she served as deputy in charge of the Long Beach Juvenile Branch. Our final speaker is Liz Bronstein, a seasoned public defender with over 24 years of service in Los Angeles County. Liz is the sole DJJ and SYTF attorney responsible for more than 70 clients in the secure youth treatment facility. And youth that are on reentry probation. She also played a key role in preparing for the DJJ's closure. And I'm sorry, I keep losing my notes here. She played a key role in preparing for DJJ's closure by transitioning youth to LA County and serves both the Los Angeles DJJ Task Force and DJJ Transition Team. Liz has been recognized with multiple awards, including PJDC's Juvenile Defender of the Year Award in 2023 and the Rigoberto J. Arechiga Award, Youth Justice Award in 2024. So let's give a warm welcome to our speakers as we begin today's session.
Good afternoon. Thank you for joining us. So first, I wanted to state that this is the first in a series of 4 webinars designed to provide technical assistance to justice partners throughout the state of California. It's part of an OICR grant that we're grateful to have received, and we thank them for their support and guidance. this particular first webinar is going to focus on an introduction to the post-disposition SYTF collaborative courts, which is the model that we have assembled in Los Angeles that we'll talk about in a little bit. Before we look at the model that we're using right now, I think that it's helpful to look at where we've come from, to look at the past, and to make sure that we see where we've gone and what hasn't worked for us and where we're going to go next. Next slide. So DJJ was a massive failure in a lot of ways. It was a failed experiment in a lot of ways. And after 132 years of troubled history and some really devastating consequences, the governor announced his intent to close DJJ in 2020. Next slide. And part of the reason for the closure was that it wasn't just the abuse and the disconnection and the failures. It was that there was an ultimate failure to rehabilitate. The most recent recidivism numbers done by the state were in 2017. And as you can see, a key takeaway was 74.9% of the youth were rearrested, which means that you could toss a coin up in the air and you would have better odds. So you have to wonder what we did to put our finger on it. Did we hurt more than we were able to help? Next slide. At the very end, when DJJ was very close to closing, there were staff shortages and there was COVID. And in 2023, youth spent more than 14 hours a day in their cells. And in the behavior treatment module, more than 20 hours a day. And that was reported by CJ at the end. So now let's look forward to where we're going. Senate Bill 823, it's the intent of the legislature and the administration for counties to use evidence-based and promising practices and programs that improve the outcomes of youth in public safety, reduce the transfer of youth into the adult criminal justice system, ensure that dispositions are in the least restrictive, appropriate environment, reduce and then eliminate racial and ethnic disparities, and reduce the use of confinement in the juvenile justice system by utilizing community-based responses and interventions. So that's the blueprint, that's the intent. And the reason for that is really evidence-based. Next slide. The evidence shows that when our youth are connected to their families, they have greater success. When they're connected to their communities, they have greater success. There's a lower recidivism rate, and we're able to help our youth make a better transition back into the community. Next. But we worried that without a more restrictive system for higher needs youth, that the twin intent of reducing the transfer of youth to criminal courts would increase. So in its place, SB 92 created a realigned version of secure youth treatment facilities. That's not to say that we were relocating DJJ, but it would be a realigned version to the counties for youth with higher needs. Next step. And that brings us to the question. Although there were things at DJJ that worked, the idea wasn't to pick up things from DJJ and just transfer them to the counties and put them into place again, because we know that ultimately it didn't work. We also know that we've learned a lot about trauma-informed programming and the types of needs that our youth need. So the question is, how do we create a secure youth treatment facility that helps more than it hurts? In Los Angeles, we sat together and we thought about what the shortfalls were. And together we decided that we were going to create a collaborative court model. We have about 250 kids in Los Angeles that are in the SYTF. About half of them are out in the community, and that includes the Prop 57 kids. And together we wanted to address what we recognize to be the harms of the past. We had kids coming back from DJJ who were almost like they had been disappeared. They were reemerging into communities and families that they had had no part of for many years because of distance, because of time, and they really had nothing. These kids arrived back in Los Angeles untethered, not even tethered to the lawyers or to the court. And we wanted to try to create a model that was trauma informed, that could support kids and that could address their needs as we went. So to that end, we try really hard to get to know our kids. We've brought in CBOs who spend a lot of time in custodial environments and in the field getting to know our kids. And together, we are a dedicated staff that work very closely. And of course, it's an adversarial system. So there's plenty that is litigated, but we see that we have much more in common than areas that we differ. We both want safe, both sides, I mean, and all of us, we want safe communities and we want our youth to go on and live happy, fulfilled lives. So, next slide. The way we're set up in Los Angeles, because of the numbers, and I know that those of you in smaller counties heard the number of 250 and probably gasped, and it is a lot, but we're divided up in 4 separate SYTF courts, one in Sylmar, one in Antelope Valley in Lancaster, Compton, and East LA. And Compton and East Los Angeles both take cases from other courts as well. So they're fairly robust calendars on the days that we have SYTF. And the way we're divided up is, next slide, please, is that there's one PD and there's one APD. There's 2 district attorneys. They each cover 2 courts. And then we have independent bar counsel from ITCO. And for the most part, there's a consistency of lawyers who are staffing the courts. And together we tour facilities, we tour programs, we look at less restrictive places together, and we meet quite often, and there's an open line of communication. Very rarely do we go into court on matters without having consulted with the district attorney and the CBOs and doing MDTs either with probation or in addition to probation with CBOs and the district attorneys. So we can really make sure that we're making decisions together in a way that, from the defense side that benefit our clients, from the prosecution side, ways that benefit the community. Because as I said, I think that in a lot of ways we have much more in common than areas where we differ. And it's an accepting court. It's important for us to get to know our kids. If it were up to me, if time weren't an issue, I would bring in our clients once a month, because I think that time in front of the court, getting to know the district attorney, getting to know counsel, having CBOs, community-based organizations speak on their behalf is priceless. And it's a way that we can learn what our clients' needs are and make them feel comfortable, because it's not a place where we're prosecuting them again and again for their crime. It's a place where we recognize that they're more than the worst thing that they've done, and we're going to treat all the people that come into the courtroom as human beings who have a voice. I'm going to pass it on to Jane Brownstone, who's going to identify the most appropriate youth to go to SYTF.
Thanks, Liz. So as Liz was saying, SYTF was not intended to just be DJJ at the local level. The legislature gave clear instructions that intended SYTF to be an entirely different treatment model. And SB 823 further provided us with new instructions that it was the law's intention to keep youth in the juvenile justice system, and it also mandated that dispositions were to be to the least restrictive, appropriate environment. So as a prosecutor, as Liz said, sometimes it is adversarial and we don't agree on everything, but we always do try to collaborate and work together as we can. And I know for some of the prosecutors, it's hard for us to adjust to juvenile court when we come from adult court, because the assignments are very different and the goals are very different. And we may not always fully agree with the laws, or may sometimes think that the laws move too quickly for the accompanying infrastructure to actually achieve the goals of the laws. However, we've all done jury selection where we have over and over again told the potential jurors, it's your job to follow the law, even if you don't agree with it. And as prosecutors, one of the first things we do is take an oath to uphold the laws of the state of California. And under California law, juveniles are differently situated and they are treated differently. And the goal of juvenile court is rehabilitation and not punishment. So if you are at the point where you are considering a disposition in juvenile court, the youth was either not eligible for transfer to adult court, your office decided it was not appropriate to seek transfer, or the court found the juvenile fit to be handled in juvenile court. So SYTF is the most restrictive option in the juvenile disposition scheme. And under the current law, each youth has to be evaluated on individual factors prior to being committed to SYTF. So that means that not all 15-year-olds who commit 707B offenses should automatically end up at SYTF. It's not one size fits all. Additionally, if that's the way we are looking at it and we just automatically say you committed a qualifying offense and you are of the qualifying age and send all of our youth to SYTF, we are going to exhaust what services we actually have in place for treatment, and we are going to be unable to provide treatment to the youth that need the most services and pose the greatest danger upon release. So we're really not doing our part to provide rehabilitation and protect our communities if we are over-exhausting the system that's supposed to provide treatment. So let's talk about SYTF eligibility, and this is under Welfare and Institutions Code, section 875A1 through 3. It's for youth that are 14 years or older. There has to be a qualifying offense, which is a Welfare and Institutions Code section 707B. The offense has to be the most recently committed in time, and the court has to make a finding that SYTF is the least restrictive appropriate disposition. So the first three factors are just check marks. So I want to talk to you about the last factor, which is the most important one that you should be considering when you're looking at potential dispositions and alternate dispositions from SYTF. And that's the least restrictive appropriate disposition. So the court is instructed that they can consider all relevant material, including the recommendations of counsel, the probation department, and any other agency or individual designated by the court to advise on the appropriate disposition of the case. And in determining what the least restrictive appropriate disposition is, the court has to look at the severity of the offense, including the minor's role in the offense, and their behavior and the harm done to the victims. So let's say you have a robbery with a group of minors and the minor you're looking at is not the main actor. Maybe SYTF is not the appropriate disposition for them, and you should look at other potential alternate dispositions, even though they are eligible under the first three factors. The second criteria is previous delinquent history and the adequacy and success of previous attempts to rehabilitate. SYTF should not normally be your first jump, especially if there's no prior attempts at treatment, because SYTF is our last step in treatment within the juvenile system. So it's really something that is for the most serious and high needs cases. A C is the programming and treatment and education offered and provided at SYTF and whether it's appropriate to meet the treatment and security needs of the ward. The next factor is, can the goals of rehabilitation and community safety be led by a less restrictive disposition? This is always difficult because we cannot tell the future, so we're always making our best guess at that one. And E is the age, developmental maturity, mental and emotional health, sexual orientation, gender identity, and expression, and any disabilities or special needs affecting the safety or suitability of an SYTF commitment. So when you're looking at disposition, you really need to look at the child, because you have to prove and go through all of these things in determining whether or not SYTF is the least restrictive, appropriate disposition. And it's not always going to be. And I encourage you to look at other potential dispositions to determine whether or not there is a less restrictive, more appropriate disposition. So one of the ways that you're going to have to do that when you are looking at SYTF as opposed to non-SYTF dispositions is you're going to have to get outside of the courtroom and actually go out there and visit the programs, visit SYTF, visit your suitable placements, visit the camps, figure out what services are actually being offered, meet the treatment teams. Because how are you going to successfully argue that a youth requires or does not require SYTF if you are not aware of the other less restrictive services and what they have to offer? Likewise, how are you going to argue that the youth belongs in SYTF or does not belong in SYTF if you don't even know what services are available in the SYTF program? So do not just rely on the reports that are coming into court. You need to go out and actually learn the programs, and you're going to be in a much better position to argue to the court what you think is appropriate when you're coming from a place of actual knowledge. And you're going to be in a much better position to suggest an appropriate program and treatment for the youth when you are familiar with the practitioners and treatment teams. So let's talk about some times when you should potentially consider an alternate disposition other than SYTF. One of the times I suggest you consider alternate dispositions are when you are considering a baseline of less than 3 years. SYTF is the most restrictive, and if you are considering a lower baseline, I encourage you to look at why you are considering a lower baseline and if the factors actually warrant an SYTF commitment. Because, for instance, if you're considering a baseline of 1 year and the youth is doing well in custody prior to the commitment to SYTF, and they continue to do well in custody in SYTF as they have indicated they would, there's a potential that that 2-year baseline could go all the way down to 1 year. And that's very little availability for treatment. So there's potential that another disposition would have been equally appropriate and actually given more resources and a better treatment guideline. I also suggest with particularly young youth to consider alternate dispositions. I know for a lot of the counties, there's only one SYTF location and the youth are not separated by age. So when you have a 14-year-old in there for a robbery with a multiple homicide youth who is now 24, that sometimes can get difficult and may not be the best solution for treatment. Additionally, youth with specific mental health needs, that's always something to consider, as well as with gender-related needs, and youth with sex offenses. DJJ, because it was treating the whole state, had a specific unit and treatment team for sex offenses. With the treatment now going to the individual counties, there is less availability within the SYTF facilities to treat or create specific sex offense units. So we've run into problems with the ability of youth with sex offenses to be able to receive treatment while being able to safely, fully integrate with the populations. So that's something to be aware of. And something to consider is that if you have a youth who is otherwise eligible for SYTF, they're 14 years or older, they have a 707B offense, and it's the most recent one committed in time. Just because you consider an alternate disposition or do an alternate disposition, for instance, maybe you do camp first, that does not foreclose an SYTF disposition. If they go to camp and they are unsuccessful and more treatment is necessary, they can always be sent to SYTF on a disposition on a Welfare and Institutions Code 777 violation. So you're really just giving yourself more time to figure out what the appropriate treatment is, and hopefully, potentially, that less restrictive alternate disposition is all that was needed. So one of the alternate dispositions that I want to talk about, which is less known, is the Pine Grove Youth Conservation Camp in Amador County, which is run by the CDCR Division of Adult Institutions and serves youthful offenders. So at Pine Grove, training is provided by CAL FIRE, and the youths are certified to engage in wildland fighting fire operations. And the majority of the emphasis in training is really allowing the youths to develop skills and work habits to where they could leave with actual ability to become firefighters and to have a lucrative career, actually giving back to the community and serving the community. And for some of them, really kind of trying to put a dent in that maybe karmic debt that is there. And for the Pine Grove program is extremely challenging, both physically, mentally, and emotionally. These youth work extremely hard. It's very regimented, it's very thorough, and for the right kid, it can do absolute wonders. For the kid that needs a firm hand and just needs the task, it can just turn a child around. It's also great sometimes for a youth who needs to escape their community, to escape certain influences, because it is up in Amador County. For other youths, it's not the right fit and it's a complete disaster. So you really have to use your discretion. And the ability to send a youth to Pine Grove is under Welfare and Institutions Code section 730 A1D. So I want to talk to you about some of the amenability considerations for Pine Grove. They will only accept youth who have a petition sustained for a felony offense. The youth must be 18 years or older. They will not accept youth who are currently on medication, because the youth at Pine Grove actually get sent out to do fire suppression. They get sent out on fires. So they do not have the ability to regulate the medication when they are out fighting a fire for multiple days. They also will not accept any youth who have a sustained petition for sex or arson offenses. You cannot just order a youth to Pine Grove. They have to be screened and accepted. So if this is something you're considering prior to disposition, have your judge order that they be screened for Pine Grove. Another requirement is that the youth must be in a custodial facility for a year prior to going to Pine Grove. And in addition to that, Pine Grove, while it's in the middle of nowhere in a forest in Amador County, it's not locked down and they have an open dorm setting. So it's also important that the youth has a good history of nonviolence in custody so that they can show they can live in an open dorm setting. The youth can also be discharged at any point. Pine Grove can say they're not performing necessary to the program standards, and they can send them back to your county. But again, that would potentially be a violation, and then you consider next steps. For instance, potentially SYTF or some other alternate disposition. Something to know as well is that Pine Grove, unlike regular camp, is not limited to camp time limits. The commitment term can be anywhere up to the maximum confinement, but it cannot exceed it, which is particular the midterm on the offense. So we have talked about when we should consider potentially alternate dispositions. And for some youth, that may be appropriate because we are really supposed to be trying to rehabilitate youth and steer youth into the most appropriate place where they can receive treatment and keep the community safe. For some youth, that is not going to be anything but the secure youth treatment facility. So that does not mean, though, that all youth that can get committed to the secure youth treatment facility are going to be treated the exact same way. Each youth still needs to be considered based and treated based off their individual factors. So Courtney is going to talk about how you go about crafting an appropriate secure youth treatment facility disposition.
Thank you, Jane, and thank you everyone for joining us during your lunch hour. Crafting the appropriate SYTF disposition. Once you've reviewed the circumstances of your case and evaluated potential disposition options that are available to rehabilitate the youth, and you've decided that an SYTF commitment is the least restrictive but the most appropriate option available, it's time to talk baseline. Slide. California Rule of Court 5.806. As of July 1st, 2023, the Judicial Council provided us insight and direction into how the parties and courts should determine the appropriate baseline term. These rules can be found in California Rule of Court, Title 5, Division 3, Chapter 13, Article 4, Rule 5.804 through 5.808 is where you're going to want to look. Specifically, when you look at Rule 5.806, which is the Secure Youth Treatment Facility Baseline Term, subsection B, that provides the court with direction to the court on which factors and criteria to review and how to consider those criterion factors, as well as how the court may exercise discretion in evaluating each criteria. In the review of the criteria, the court may give weight to any relevant factor, including but not limited to the factors listed under each criteria. The goal in creating the baseline term, the objective, is that the court must select a baseline term that is no longer than necessary to meet the developmental needs of the youth and to prepare the youth for discharge to a period of supervision in the community. And I didn't just make that up, it's in the statute. Slide. Setting the baseline term. The baseline is based on the most serious and recent offense for which the youth has been adjudicated. And that is, when I say most recent offense, it's the commission of the offense. That's the most recent offense committed. It's important to note that the baseline may not be aggregated. It is set based on the most serious and recent offense. So if the youth is charged with multiple 707Bs, you cannot aggregate those to create a higher baseline. You're just going to choose the most serious and most recent offense, or the court is going to select that. The baseline is described in that it shall represent the time in custody necessary to meet both the developmental and the treatment needs of the ward to prepare the ward for discharge and on a period of supervision into the community. This is determined by the offense-based classifications that are approved by the Judicial Council and can be found in the California Rules of Court. Now, what are these offense-based classifications, you say? This is the new baseline matrix. It can be found in California Rule of Court 5.806, subsection D. Prior to July 1st, 2023, there was no baseline matrix. The courts utilized criteria and used the projected board dates from the Department of Juvenile Justice as a placeholder. We no longer do that. The matrix that we have up here, 5.806D, is now the appropriate matrix to look at when deciding the baseline term. The matrix, the previous matrix included determinate terms, like for example, for murder, PC 187, there were 7 years. Now, as you can see, that's a category A offense, but there is a range of 4 years to 7 years. As of that new baseline matrix being placed into law, we now have ranges, which places even more importance in evaluating the criteria and factors to determine the baseline. The baseline necessary to rehabilitate the youth. For example, one of the criteria you see here is juvenile delinquency history. Now, if you have a youth who has been through several interventions with the juvenile court prior to the commission of this 707B offense, that is potentially a factor in aggravation to determine that that youth may benefit from a longer baseline term on the higher end of the range. First, a youth who has no delinquency history and which could potentially be a factor in mitigation that would support a baseline term on the lower end of the range. Of course, prior delinquency history is just one of the 4 criteria that the court must review and consider. No one criteria is dispositive. So you can't just look at criteria 1, which is circumstances and gravity of the commitment offense, and say off bat, this was a horrific offense, we're going to the highest end of the matrix. The court must weigh and evaluate each of the 4 criteria in determining the baseline. And I would encourage the parties when negotiating baseline terms, if that's something that you're doing, to go through each of these circumstances, each of these criteria, and really evaluate them specifically with the individual that is going to be placed on an SYTF commitment to determine the baseline term. No one criteria is dispositive. As I said, each criteria or factor should be weighed and evaluated. Now, the baseline term, pause, Jane, can you go back? So the 4 individual criteria, as we have here, are circumstances and gravity, prior history in the juvenile justice system, the confinement time considered reasonable and necessary to achieve the rehabilitation of the youth, and the youth's developmental history. These are the 4 factors that the court must review and make a record of in its selection of the baseline term, each of the 4 factors. Next slide. It is important to note of the enumerated factors that are outside of the youth's control, any of the enumerated factors that are outside of the youth's control must not result in a longer baseline term than otherwise needed to meet the objective. And the objective is developing a baseline term that is necessary to meet the developmental needs of the youth and prepare the youth for discharge to the community. So I say that because, for example, a youth's foster history, that would be a factor outside of the youth's control. And that factor alone must not result in a longer baseline term than would otherwise be needed to meet the objective of rehabilitation. So you really need to focus when determining a baseline term on the factors that are within the youth's control. Anything outside of the youth's control should not be used to make the baseline term longer. Next slide. As a result of the complexity and nature of SYTF supervision, if your county follows the Los Angeles model, then there is specialized SYTF supervision deputy that only handles the cases post-disposition. It is extremely important to implement a process for the trial deputy to provide the SYTF deputy with information in how the court or the parties arrived at the baseline term, as well as identify any known rehabilitative needs that must be addressed during the baseline term of confinement. That helps inform the SYTF deputy on how to best approach the individual rehabilitation plan and how to best make sure that there are no untapped resources and that we are providing everything we can to meet the objective of an SYTF commitment. Next slide. A court is not, so we have a collaborative court model. But it is important to note that a court is not truly collaborative unless all parties make an effort to participate in that collaboration. If one party is not interested in a collaborative court process, then the plan and the collaboration in the court will fail. It cannot just be the prosecutor adjusting a traditional perspective, maybe that is a perspective of punishment. That is not a collaborative court. The collaborative court has to be every party, not just the prosecutor, not just the defense, not just probation, stepping out of traditional roles to collaborate together, understanding that we all have the same interest and the same objective, which is to help rehabilitate this youth that has come before us so that in the future they are a productive citizen, that they can have a productive life, and no further harm will come to the community. If there's only collaboration on one side, then that's just a courtroom with one less voice. It does not support the objective. It does not support everyone having a seat at the table. So it might be uncomfortable at first to adjust to this collaborative model because it is very different than the adversarial model that we typically use in adult court. But part of that adjustment in perspective is what is necessary to make a model like ours work. Next slide.
So I want to talk about the switching your mindset from predisposition to post-disposition as a prosecutor. As I talked about earlier, SYTF was not designed to punish. And if that is what you go into court fighting for, you're going to be fighting a losing battle and you're going to be just pushing a boulder up a hill that's going to keep rolling back on you. Every youth will be released back into the community sooner rather than later. So the way we protect our communities and honor our victims is by making sure that you actually contribute to the rehabilitation of the youth, because that is what we can do to try to make sure that there is not another victim. So we all, in essence, want the same goal. We want the youth to succeed so that nothing like this ever happens again. And by sitting there and just yelling for punishment, you're not doing that. You are just waiting for the same thing to happen again upon release. You're not contributing. So I think it's really important to try to reevaluate post-disposition and switch into a different mindset of how you can aid the prosecution and help keep your community safe. And I think one thing that helps with this switch mentally from the prosecution side is that we do have DAs specifically assigned to SYTF who do not necessarily prosecute the case from the beginning, because this switch is a lot more difficult when you've spent months or a year arguing in the guilt phase or for transfer over and over again. So that's one of the things I think that helps our collaborative court is the fact that we have SYTF attorneys dedicated just to SYTF. So that's something to consider if you're doing a collaborative court.
So I'll talk a little bit about how it's difficult for the defense to switch to that side, because obviously our duty is to our clients and it's to represent our clients' wants and not for us to be paternalistic or maternalistic and determine what that should be. We ultimately work at our clients' orders or at their requests. But that doesn't mean that we can't collaborate. That doesn't mean that we're not fighting for our clients. I think that the best way to protect and enforce our clients' rights is to work in a system that is a holistic system where we can talk about things and we can, express our clients' views and their wants and desires. Like the district attorneys, Jamie and I, at least in our practice, we're post-dispositional lawyers, and I think that that's very helpful as well, because SYTF, was not designed to relitigate the facts of the case. Post-disposition representation is entirely different. And I think that, from my experience, I'll meet with a client when they first become my client, once their case is solved or resolved rather. And, I'll say, like, where do you see yourself in 5 years? Where do you see yourself in 10 years? How can we help you get there? We go around one time in this lifetime. So what can we help you with? What can I help you? How can I get you there? Because ultimately, our clients are going to come back into the community, and we want them to come back and live happy lives. We want them to be able to succeed and have success, but also to find a way to resolve and forgive themselves of the harms that they've caused. Ultimately, they've got to be able to live with what's happened and not be haunted in order to be productive members of society. So it's very important sort of that we realize that getting along doesn't mean that we're rolling over or that we're not representing our clients. We can do both. And along those lines, I think one of the biggest stretches for defense lawyers is to bring the prosecution into the planning and the speaking to our clients and the discussion of what their hopes and dreams are. And Jamie's going to talk to you now about the individual rehabilitation plan and the role that our collaborative court plays in that.
Thank you, Liz. Yes, I'm just going to talk to you guys briefly about how we approach what's called the Individual Rehabilitation Plan, or the IRP, in collaborative court. This is the IRP hearing is usually the first court appearance that a youth is going to appear in an SYTF court. So I'll talk a little bit about how we approach that as a team. So next slide, please. So I'm going to give you guys a very basic rundown of the law pursuant to 875D1. I'm sure most of you already know this, but at the time of commitment to an SYTF, your sentencing judge is going to set a date for an IRP hearing within 30 days in one of our, if it's in LA County, it's going to be in one of our 4 SYTF courts. The language in 875D specifically says a plan may be developed with a multidisciplinary team consisting of youth service, mental and behavioral health, and education. And the language specifically provides the prosecutor and defense counsel may provide input. In LA County, our judicial protocol directs probation to invite the district attorney and defense counsel and include them in the IRP process. If you are from a county that where you're having difficulty attending the IRP and you want to, our suggestion is to you that you ask the sentencing judge to have you place in the minute order that you're the attorney of record and that you would like to be invited to the IRP. Hopefully that will get you that invite from probation. Okay, next slide. So an IRP, in theory, in a perfect world, is supposed to do all of the following, according to 875D1. First, identify the youth's needs in relation to treatment, education, and development, including any special needs the ward may have in relation to health, mental or emotional health, disabilities, or gender-related or other special needs. It's also supposed to describe the programming, treatment, and education to be provided to the ward in relation to those previously identified needs during the commitment period. It's obviously supposed to be trauma-informed, evidence-based care. And lastly, the ward and their family are given the opportunity to provide input regarding the needs of the ward. Sometimes that presents as probation calling the family and asking for input, and other times the family actually does participate in the IRP. It's important to note that it is actually the youth who decides what family is going to be involved. I mean, we have had situations where the youth wants to distance themselves from their family. So that does happen. So we should always be mindful of that. Next slide, please. Following approval of the IRP, the court must set progress reviews not less than every 6 months. At this hearing, the court shall evaluate the youth's progress in relation to the IRP. All progress is always measured in terms of whether they're meeting the IRP goals, what progress they're making in regards to the IRP. At that 6-month hearing, the court's going to make a determination if a baseline term should be modified. It could be anywhere from 0 to 6 months, taken off the baseline term. Prior to that progress report date, in LA County, probation will hold an MDT, which we're going to talk about in just a minute. At this 6-month hearing, the court's going to consider recommendations of counsel, probation, CBOs, behavioral education, or other specialists. And in LA County, all of those agencies are able to participate in both the MDT and the 6-month court hearing, and they do participate in our 6 months hearings. In LA County, we also routinely set 3-month hearings as well. I know Liz mentioned that we'd all like to have our clients come in even more than that, but realistically, we try to have them come in every 3 months. Sometimes there will be an MDT prior to that 3-month hearing, but there's always a probation report that reflects progress towards the IRP goals. We all agree that setting these 3-month interim progress reports gives us all better knowledge of the youth. They make sure that if there are problems, if there are issues, it gives the youth a chance to tell us what's happening so that we can make corrections, we can provide encouragement. Generally speaking, I think everybody in the team feels that the more we can have the youth into court, the better. We just want, our ultimate goal is to always make sure that, the youth are on track and that we're also building these relationships with all of the players in the courtroom. Lastly, I think at the 3-month hearings, it's appropriate we start prepping for what we are looking at down the road. Are we looking at coming close to having the youth step down into the community? We can start having a conversation with the district attorney, with the judge, with all the other players about, okay, what does that look like? And just having an open conversation about what is the youth, what is the youth interested in? What do they need? What do they want to be successful when they step down? So it's also sort of keeping it on that tight track where we see them every couple of months, helps us prepare everybody for what's coming next. It makes everybody feel more comfortable when they are ready to step down into the community. Okay, next slide, please. So in LA County, it's probably a little bit different. We have a lot of people that participate in both the IRP and all the MDTs. Again, it's written in the protocol that the defense attorneys and district attorneys are both invited, and we routinely do participate in these meetings. We also have probation, case managers, and field service officers. So it might be that the case manager for the youth is present, as well as the outside probation officer. We have Department of Mental Health. We have LACO if the youth is still in high school, or Probation Education Services if they're attending college courses. We have community-based organizations, and also the youth family, again, is present for some, or at least consulted in many ways. So this isn't just the goal is so that this isn't just probation drafting a form document. This is essentially supposed to be a team that is actually considering the needs of the youth and trying to draft a document that addresses those needs. Next slide, please. So I want to talk just briefly about where we're coming from from a defense perspective when we're participating in these IRPs or MDTs. As Liz mentioned earlier, our mindset is definitely different than a predisposition advocacy. We're not talking about defenses. We're not prepping for trial. We're not trying to get a dispo. We're now shifting to think about how do we promote rehabilitation and to get the youth back into the community as soon as they are ready, and also have them be successful. So we're readdressing needs in this completely new environment. The IRP is one of the first times that we are meeting and advocating for that youth. And so again, it's a lot about building rapport, but I think it's important to always remember, as a defense attorney, we have to be cognizant of privilege. Specifically, like for example, LACO or education or special educations issues that may come up. There are HIPAA issues or medication issues that may come up. So we want to be mindful that although some of the parties at the table may have access to that information, not everybody does. And so we need to be mindful about what's appropriate for probation to be privy to, that's going to go in that report, that's going to be shared with everybody. And it's also important to think about what's appropriate to be discussed in front of the youth. Is it appropriate to be discussing, potential medical issues in front of the team? Is it appropriate to be discussing, that the youth may have a very low reading level? I mean, you just have to be constantly cognizant of what is going to be helpful to be discussed in front of the youth and what is appropriate to go into that report. So next slide, please. And I'm actually going to hand it over to Courtney.
I'll handle
I think
this
you're doing
one,
this one.
Jamie.
To talk about where the prosecution is coming from in their standpoint and when they participate in the IRP.
So as we all know, juvenile jurisdiction is limited. Each of the youth we work with will be released back into the community. So with that information, it's important to go into the SYTF commitment with that perspective. As a prosecutor, traditionally, my knowledge base surrounding a case is limited to police reports or probation reports or any other any mitigating information that the defense shares, doctor's reports, those types of things. That's a very small knowledge base. With an SYTF commitment, like we said earlier, our objective is to rehabilitate this youth because they're going to return to the community, and we want them to be a positive member of the community and make sure no further harm occurs at their hands. So participating in the multidisciplinary team, the MDT, for the IRP, helps me as a prosecutor to understand this specific individual youth's needs, any areas of challenge, any areas of success. And with that information, the prosecutor can make more informed recommendations on the individual youth's rehabilitation. I always say that my decision is only as good as the information that I'm given. The more information that you as a prosecutor have, the more involved you are, the more informed your recommendations and decisions will be. If you're invited to participate in an MDT, I highly suggest that you do. Slide.
So getting close to the end here, I just wanted to talk about how both sides, I think, sort of view the IRP as this sort of living document. And what I mean by that is that these youth have likely been detained for quite some time and are going to be detained now in a new setting, in an SYTF setting, for, again, potentially quite some time. We all know that youth grow and mature and change, and that age group that's very common. So it's an evolving process to continually work with probation, to add those needed supports and programs, to go out and find the CBOs that can address the client's needs to help accomplish their goals, or subtract it when those are no longer necessary. But we also want to always be mindful of not constantly moving the goalposts, as compliance with the IRP is the measure of progress. So we always want to be mindful of that as well. And I think we all try to do a good job of that in our court here. A youth may not initially be ready for example, for something like tattoo removal, but give them enough time, having communication with our credible messengers and programming, and that may change. Another area that we often deal with sort of that's evolving is sort of substance abuse. Sometimes we find after a youth has been programming and detained for a while that substance abuse is actually a much bigger issue than we thought. So then we have to tweak the IRP to get those services that are more intensive for that particular youth. So it's constantly, we have to be constantly able to check in with them and to be able to change and modify it when it's appropriate, and to also take things away when they're no longer appropriate. Next slide.
So we're trying to do the best we can, and we're sort of building the ship while we're on the water, but we do know that we're just lawyers, and our expertise is limited, and we reach out and we rely very heavily on our community partners, and that is what the intent of SB 23 is. That's what evidence has shown. So this is going to be a great introduction for our next webinar, which is going to be the role that the community-based partners play in our collaborative court model and in the SYTF in Los Angeles. So on behalf of the Los Angeles SYTF Collaborative Court, we thank you for joining us today.
Thank you to our presenters for sharing your expertise and your experience. We really appreciate it, and thank you to all of you who attended. I will email out the PowerPoint and the MCLE at some point, either later today or early tomorrow morning. I see that some of you have your hands up, but unfortunately we are out of time and our presenters do have to get to court. So I suggest that you email them directly for your questions. Have a great day, everybody.